This is the W2 report with Sanji Himura. Here's Sanji.
Hello everyone and welcome to another exciting episode of the W2 Report. I am your host, Sanji Himura. Today, we take a look at the tactical nuke that was dropped in the USSR Wives legal saga. But before we proceed any further, let us go over the ground rules with Mr. Lan.
All right, rule number 1, don't be the dick. Especially, do not go after anyone that we mention in this episode. Rule number 2, if you have questions whether or not you're being the dick, refer to rule number 1.
Please do not go after anybody we may talk about today. That will result in your ban from this community. Now, let us now proceed into the SSR Wives. This is the defendant's motion for a temporary injunction modification of the May 29, 2026 preliminary injunction. And they want an expedited evidentiary hearing, and they want also evidence, emergency preservation, and emergency discovery. Reasonable enough, right? Well, given what happened in the Turkey show, please, let us do our jobs and report. So, the defendants moved pursuant to Florida Rules of Civil Procedure 1.610 and other applicable law for a temporary injunctive relief, clarification or modification of this court's May 29, 2026 preliminary injunction, an expedited evidentiary hearing, and emergency preservation and emergency discovery. Bam! Right off the gate. Now, introduction. This emergency motion arises from plaintiff XYZAI Inc. and Joseph German's use of materially false statements concerning this court's May 2026 preliminary injunction to induce third-party platforms to restrict, remove, suspend, or impair defendants' independent business activities related to Synapse Chronicles and Corpus Works, LLC. Plaintiff represented to Patreon, YouTube, Valve, and Steam that this court had ruled that Synapse Chronicles or Syn Chronicles used stolen source code and assets from SSR Wives, unlawfully used plaintiff's intellectual property, and violated plaintiff's rights, and was subject to a judicial prohibition against promotion, hosting, development, or launch. The May 29 order contains no such findings and imposes no such platform-facing restrictions. The May 2029 order contains at most preliminary findings on a contested record, including a narrow finding concerning alleged menu interface similarity based on screenshots. It does not identify copied Synapse source files, asset files, repositories, models, textures, scripts, audio files, build files, trailer files, or other specified protected expression. It does not adjudicate Synapse Chronicles as infringing, stolen, or owned by the plaintiff. It does not prohibit promotion of Synapse Chronicles. It does not direct Patreon, YouTube, Steam/Valve, X/Twitter, Ko-Fi, Discord, payment processors, publishers, investors, or any other third party to restrict or remove Synapse Chronicles or related accounts. The plaintiff submissions, therefore, materially expanded the court's order beyond its text and used private trust and safety systems to obtain relief this court did not grant. The resulting harm is immediate and irreparable. Steam disruption, YouTube trailer removal after approximately 22,000 views, Patreon suspension, Ko-Fi removal, Twitter X disruption, Discord limitations, publisher diligence harm, community confusion, and loss of post-launch window momentum and reputational injury. This conduct is not isolated. It follows the founder lockout, disputed ownership claims, and alleged misuse of Simon Dickerson's personal and privileged account environment, alleged copying of Stealth Agent IO, public harassment, and public control abuse. Defendants therefore seek immediate clarification, corrective platform relief, preservation, expedited discovery, and personal account no-use relief, and status quo protection. Factual background. The May 2029 order did not make the findings plaintiff claimed to platforms. The May 2029 order was entered on a contested preliminary record. It did not finally adjudicate ownership of SSR Wives, Hen Studios, Synapse Chronicles, Corpus Works LLC, Stealth Agent IO, or any founder's split rights. The order contains a limited finding that the plaintiff's exhibits 76 and 78 showed Cortez developing Sin Chronicles and that the main menu interface was substantially similar to SSR Wives. The hearing testimony was based on side-by-side screenshots that was expressly limited to those menus. That testimony was not a forensic source code comparison, asset file comparison, character file comparison, trailer review, Steam page review, or game ride infringement adjudication. The screenshot plaintiff relied upon was an obsolete early development preview from a Hint Protag X Pro Twitter post. That post has been removed long before the March 6th hearing. The character reference in the testimony was not a named Synapse Chronicles character, was not in Synapse Chronicles, and will not be in Synapse Chronicles. The court did not find that Synapse Chronicles contained SSR Wives source code, SSR Wives assets, SSR Wives characters, SSR Wives audio, SSR Wives story material, SSR Wives branding, and or protected SSR Wives expression. The court did not adjudicate Synapse Chronicles as a derivative work. The court did not prohibit Synapse Chronicles by name. The court did not enjoin promotion, hosting, launching, development, or publication or marketing of Synapse Chronicles. B. Plaintiff made materially false platform statements. The plaintiff's platform submissions materially misrepresented the court's order. First, Gurman's June 8th, 2026 Patreon DMCA submission stated that the court explicitly ruled that Sin Chronicles used stolen source code and assets from SSR wives and legally prohibited the continued development, launch, or promotion of a derivative game. Second, YouTube Studio identified XYZ AI Inc. and support at Stealth GPT AI as the claimant and stated that the reason for removing the Synapse Chronicles trailer was that Florida case, blah blah blah, had ruled that Synapse Chronicles unlawfully misused the SSR Wives IP and enjoined its promotion. Third, Valve Steam Records identify copyright owner XYZ.AI.Inc. and stated that Synapse Chronicles is a direct, unauthorized derivative work that misappropriates stolen source code, assets, and intellectual property. That the court recognized Synapse Chronicles as violating plaintiff's rights, and that the defendants changed the name from Sin Chronicles to Synapse Chronicles to evade the court's order. That Corpus Works LLC was a shell company, and that the entire game violates a standing judicial injunction. Those statements are materially false. The May 2029 order contains no stolen source code finding, no stolen asset finding, no finding that Synapse Chronicles unlawfully misuses SSR Wives IP, no finding that Synapse Chronicles violates plaintiff's rights, and no finding that Corpus Works is a shell company, and no injunction against promoting or hosting of Synapse Chronicles. Plaintiff's June 12th show cause motion repeats the same improper premise by asking this court to treat Synapse Chronicles as a renamed derivative of Sin Chronicles built on allegedly misappropriated SSR Wives IP. That is not what the May 29 order said. C. Plaintiff targeted platforms most important to a new platform launch. Plaintiff's false platform submission struck the platforms most important to an independent game launch. Patreon restricted or suspended the Synapse Chronicles Synapse head protag creator page after receiving the June 8th notice. Patreon is a direct creator funding program. After losing Patreon during launch week, damages revenue, supporter trust, member conversion, and public legitimacy. Steamworks showed that Synapse Chronicles has been retired on June 10th, 2026. Steam is the core PC game storefront and discovery platform. Steam wish lists are commercially significant to platform algorithms, publishers, investors, press, and consumer conversion. Disrupting Steam during announcement week attacks the game sales channel and business development record. Twitter X has suspended the Synapse Chronicles account at SynGameDev for alleged impersonation or inauthentic account activity on June 11th, 2026. That account was the project's public identity and announcement channel. Ko-Fi unpublished a backup creator funding page for copyright infringement on June 12th, 2026, eliminating backup funding and reinforcing the false public impression that the game has been adjudicated infringing. Discord limited or struck the Synapse Chronicles screenshots or posts, impairing the central gaming platform where fans gather, view updates, and convert into a launch community. YouTube removed the Synapse Chronicles official trailer after a removal request by XYZ AI Inc. on June 14th, 2026. I'm surprised that my video with the trailer is still up. The trailer had approximately 22,000 views and was gaining views daily. The trailer used the new Corpse Works Synapse materials, including new music created by for Synapse Chronicles, not the SSR Wives music or materials. Together, these acts attack the storefront, public identity account, creator funding pages, trailer distribution, and community channels necessary for the launch of an independent game. D. The harm is irreparable. The Synapse Chronicles was in its launch an audience-building window. The evidence showed that June 6, 2026 launch announcement, a Steam page list and wish list campaign, a trailer with significant views and engagement, a Steamworks wishlist activity, Patreon review, and membership activity, X/Twitter analytics, and publisher overreach. The harm is not limited to exceeding existing dollars. It includes a post-launch window velocity, lost Steam algorithmic return, lost wishlist conversion, lost trailer growth, broken traffic tunnels, account health penalties, platform trust score harm, publisher and investor diligence harm, community confusion, lost fan conversion, lost fundraising community, and reputational injury from platform notices false stating that a court has found stolen source code, assets, or enjoined promotion. A later damages award cannot recreate launch timing, restore daily view growth, erase copyright strike or account health consequences, rebuild platform trust, restore publisher diligence posture, or undo the public effect that of false court order based takedowns. E. Synapse Chronicles is Corpus Works independent game. Synapse Chronicles is an independent Corpus Works LLC project. It is documented through Corpus Works Company and rights paperwork supported by a U.S. Patent Office, Copyright Office ECO application opened before the June 2026 DMCA campaign. Plaintiff does not own Synapse Chronicles. The May 29 order does not say otherwise. Synapse Chronicles never contained SSR-wide source code, asset files, characters, textures, audio, story material, branding, dog girl, pup girl character, or protected SSR Wives expression. Sin Chronicles Project Sin was an early development name for an independent Corpus Works project later announced as Synapse Chronicles. That naming history does not establish infringement. Plaintiff's platform notices did not specifically copy SSR Wives expression in specific Synapse materials. Instead, plaintiff used an obsolete early development screenshot and false statements about the May 29 order to induce platform action. Founder lockout explains why platform self-help must be stopped. Plaintiff frames this dispute as former employees stealing company property. The defendants complain that the framing is false and incomplete. The actual dispute concerns a founder lockout. Simon Nickerson and Joseph Gurman operated as 50-50 co-founders and owners. The business employees, witnesses, and counterparties treated Simon as a co-founder and co-owner. The former paperwork lagged the business reality. Gurman then attempted to convert that paperwork mismatch into unilateral control after Simon relied on an October 2025 founder split communications. The founder split communications addressed founder level economics, Simon's self GDP, equity, economic rights, sale acquisition proceeds, salary and cash flow protection, SSR Wives Hen Studios treatment, lawyer implementation, and transfer of assets and admin control. These were founder level terms, not ordinary employee severance terms. The October 1 through 21, 1st and 2nd, 2025 record is central. Gurman told David Cortez that SSR Wives would be given to Simon. David contemporaneously texted Caleb Workman that Gurman was happy to give SSR Wives fully to Simon because the game would be in good hands with Simon. Simon, Caleb, and Alex discuss SSR Wives' IP-wide rights as part of the founder split. On October 2nd, Simon added IP rights on SSR Wives to the founder split chain. Gurman then responded, "I think that's a given. IP rights aren't in my name, the LLC is. Once that transfers, so do all rights." Gurman then asked whenever terms are ready to send to the lawyer, and then Simon could transfer assets admin control. Simon agreed and transferred admin control, business structure, blah blah blah, created and maintained since the company's founding. Shortly thereafter, Gurman locked Simon out and demanded a release of partnership, joint venture, equity, ownership, compensation, declaratory, and injunctive claims. That waiver demand confirms that Gurman knew Simon had meaningful ownership claims to extinguish. Florida law recognizes that a partnership may arise when two or more persons carry on as co-owners of a business for profit, whether or not they intend the legal label. Florida statute 620.8202(1). A partnership agreement may be written, oral, or implied. Florida statute 620.8101, section 8. Partners are owed duties of loyalty, care, good faith, and fair dealing. Florida statute 820.8404. Florida also recognized joint venture rights where the record shows a common purpose, joint control or right of control, joint proprietary interests, profit risk sharing, and risk sharing. Kilsack v. Cadron, Florida, 1957. Florida recognizes promissory estoppel where definitive promise reasonably induces action or forbearance where enforcement is necessary to avoid injustice. And case from 1989 is cited. The defendants do not ask the court to finally adjudicate the cap table on this emergency record. The defendants ask the court to recognize that plaintiff's disputed ownership narrative cannot be used as if it were finally adjudicated to obtain takedowns, suspensions, account restrictions, asset control, or public representations against defendants and their independent business. Personal account access, privilege, and stealth I/O require emergency relief. Gurman testified that while Simon was away from New York Comic Con, Gurman requested a password for a stated purpose of retrieving t-shirt designs. Gurman then conducted a broader investigation through Simon's login device and account environment. Plaintiff used private communications obtained from Simon's account perspective, and defense counsel objected that the evidence came from password misuse and trespass into Simon's account. Defendants contend that Gurman's accessed Simon's personal account environment, including Signal, iMessage, Discord, Gmail, Google Drive, family materials, private photos, litigation materials, and attorney-client privilege communications. Defendants further contend that Gurman remained in that account environment after the litigation began and obtained access to privileged communications and independent business materials. Simon had privately developed Stealth Agent IO in his personal account and development account as his proprietary product. Defendants then contend that plaintiff learned of Stealth Agent IO through improper access through Simon's personal files, then injected Stealth Agent IO into the March 6th hearing as alleged competition with Stealth GDP. On April 15, 2026, XYZ saw Stealth GDP publicly launched or announced Stealth Agent. These facts require preservation and discovery concerning access, provenance, naming, convention, design, development, copying, marketing, and launch. The court should prohibit plaintiff and Gurman from using, disclosing, relying upon, or further accessing Simon's personal privilege, family, legal, independent business, or Stealth Agent IO's materials except through lawful discovery and a court-approved privilege provenance process. H. Public harassment and account control abuse support bad faith. The platform notices follow a broader course of public pressure, account control abuse, and retaliatory conduct after the founder lockout. Gurman used corporate-facing accounts to attack defendants, their spouses, their families, the game community. Defendants will submit evidence of posts targeting Simon's wife, Sarah Ballock, Caleb Workman, and others with demeaning, sexualized, and harassing content. Profanity and vulgar language are omitted from this motion, but exhibits preserve the substance and context. After Gurman obtained control of @SSR Wives, contrary to the founder split record, the official game account announced it was the rightful owner. Publicly identified private persons behind the online pseudonyms accused former employees of deception, accusing Simon of plotting a coup, and publicly discussed private sexual allegations from the official game account. The account also presented SSR Wives as locked and suggested that the dispute could take years to resolve, damaging the game's own community. On June 10th, 2026, after the Synapse platform takedown sequence reached the community, Gurman used his corporate-facing @Joseph Gurman Twitter X profile, identifying as founder at Stealth GDP and owner at SSR Wives, to display a cropped Discord message from a Synapse community member expressing distress over his perceived power. That public display is prohibitive of state of mind, bad faith, and retaliatory motive. Procedural posture. The May 29, 2026 preliminary injunction was entered on a contested preliminary record. It did not finally adjudicate the founder lockout, Simon's ownership rights, the SSR Wives Hen Studios transfer, Corpus Works ownership of Synapse Chronicles, personal account access, Stealth Agent IO, or whatever any specific Synapse Chronicles material protected SSR Wives contains protected SSR Wives expression. On June 12, 2026, plaintiff filed an emergency show cause motion repeating the same false premise used in the platform notices by asking this court to treat Synapse Chronicles as a SSR Wives derivative and to enforce the premise through contempt relief. Plaintiffs now seek emergency clarification, preservation, production, corrective relief, and expedited testimony because plaintiff and Gurman are using private platform systems to obtain relief that court did not grant. Memorandum of Law. Temporary Injunction Standard. Florida Rule of Civil Procedure 1.610 governs temporary injunctions. A temporary injunction must specify the reasons for entry, describe the restrained acts in a reasonable detail, and blind only the parties and persons within the rule's scope. Florida courts generally require a movement to establish a substantial likelihood of success on its merits, irreparable harm absent an injunction, unavailability of an adequate remedy in law, and that the injunction would serve the public interest. Florida Department of Health versus Florida. Defendants satisfy each limit. B. Defendants are likely to succeed. The central issue here is document to document. Plaintiff told platforms that the court found stolen source code, stolen assets, unlawful IP use, and violation of plaintiff's rights and a promotional ban. The May 29th order contains no such findings or prohibitions. The Patreon YouTube Valve Steam records directly misstate the court's ruling. Plaintiff's June 12th show cause order motion then asked the court to enforce the same false premise. The court can compare the platform notices, the May 29th order, the hearing transcript, the actual Synapse materials. That comparison establishes that the plaintiff materially misrepresented the order. The defendants also have substantial showing on the founder lockout and ownership status issues. The founder split record contains founder-level economics, salary, cash flow protections, SSR Wives Hint Studios transfer language, lawyer implementation, Simon's reliance, and Simon's transfer of assets and admin control. Gurman's later ownership narrative is contradicted by his own October communications, witness testimony, contemporaneous third-party text, and the October 13th waiver demand. Additionally, the federal DMCA recognizes liability for knowing fault material misrepresentations and takedown notices. 17 U.S.C. 512F. Defendants do not ask this court to finally adjudicate any federal DMCA claim through this emergency motion. The point here is narrower. Plaintiffs should not be permitted to use false statements about this court's order to trigger platform remedies this court did not grant. Defendants place irreparable harm. The harm is immediate, ongoing, and not comprehensible by money damages alone. Plaintiffs' conduct disrupted Steam, platform, YouTube, Patreon, Ko-Fi, X, Twitter, Discord, and publisher-facing diligence during the launch window for Synapse Chronicles. Lost post-launch momentum, lost Steam wishlist velocity, lost YouTube trailer growth, account health penalties, copyright strike consequences, and platform trust score harm, publisher uncertainty, community confusion, and reputational injury cannot be fully repaired by a damages reward. The founder lockout harm is also irreparable. The plaintiff is using disputed ownership control to alter business reality before the court hears the ownership evidence. A later judgment cannot restore platform access, corrupted account control, lost business opportunities, or private platform records that hardened around the plaintiff's false version of the court's order. No adequate remedy at law exists. Money damages cannot restore launch timing, Steam algorithmic placement, YouTube view growth, platform account health, publisher confidence, community trust, or the practical ability to operate while litigation is still pending. Damages cannot undo privilege or personal account misuse after disclosure occurs. The requested relief is preventative and corrective. The defendants seek clarification of the order, correction of the false platform statements, disclosure of the platform submissions, preservation of evidence, the expedited discovery, and no use protection for personal and privileged materials. Public interest supports relief. Public interest supports accurate representations about court orders, honest use of the platform complaint systems, preservation of evidence, and lawful discovery. It does not serve the public interest for a litigant to tell platforms that a court found stolen source code and enjoined promotion when the court did not do so. The request of relief does not prohibit legitimate criticism or lawful copyright enforcement. It targets false statements about this court's order, misuse of disputed ownership claims as if finally adjudicated, and platform complaints that fail to identify specific protected expression and specific accused material. Balance of harms favors defendants. Plaintiffs have no legitimate interest in misrepresenting the court's order, hiding platform notices, using private trust and safety systems to obtain relief the court did not grant, or rely on personal or privileged materials without a lawful provenance process. Defendants, by contrast, face ongoing platform restrictions, post-launch momentum, funding interruption, reputational harm, publisher account uncertainty, account health consequences, and continued risk of personal and privilege misuse. Requested relief. The court The defendants. The defendants request that the court enter an emergency motion granting the following relief, or such narrow relief as the court deems just and proper. Expedited his hearing and clarification. Set an expedited evidentiary hearing on the plaintiff's platform notices, use of the May 29th order, Synapse Chronicles corpus works interference, emergency preservation, emergency discovery, and personal account users and founder lockout issues. Two, clarify that the May 29th order does not adjudicate that Synapse Chronicles or Syn Chronicles contain copied SSR Wives source code, copied SSR Wives assets, stolen source code, stolen assets, unlawful misuse of SSR Wives IP, or copyright infringement. 3. Clarify that the May 29th order does not prohibit Synapse Chronicles by name and does not direct Patreon, YouTube, Steam/Valve, X/Twitter, Ko-Fi, Discord, Reddit, payment processors, creator funding platforms, storefronts, publishers, investors, or other third parties to remove, retire, suspend, restrict, demonetize, strike, or disable Synapse Chronicles Corpus Works LLC, Cortez, Kohai, and Protag, Steam, Syn Game Dev, Steamworks App ID, the Synapse Chronicles trailer, or related accounts and materials. Clarify whether that any infringement assertion must identify specific protected SSR Wise expression allegedly copied and the specific accused Synapse Corpse Works material allegedly containing that expression. Clarify that the May 29th order was entered at a preliminary injunction stage on a contested record. It may not be represented as final merits adjudication, rejecting Simon founder splits ownership claims, adjudicating Synapse Chronicles as plaintiff's property, or adjudicating that Synapse Chronicles materials as infringement. B. Anti-misrepresentation and platform non-interference. Prohibit plaintiff, government, their officers, agents, employees, attorneys, where applicable, or persons acting in active concert with them from representing any platform, payment processor, publisher, distributor, investor, partner, journalist, fan, or counterparty, or commercial counterparty that this court found Synapse Chronicles containing stolen SSR Wives source code assets and unlawfully misuses SSR Wives IP, violates plaintiff's rights, violates a standing judicial injunction, or is enjoined from promotion. Prohibiting plaintiff and government from using the May 29th order, disputed ownership claims, copyright notices, takedown, trademark notices, impersonation reports, account recovery process, trust and safety complaints, or other similar platforms, systems to restrict, remove, suspend, retire, demonetize, or interfere with Synapse Chronicles, blah, blah, blah. Require any future platform submission concerning Synapse Chronicles be simultaneously disclosed to display defense counsel with the exact accused material, exact protected material, full platform submission, and all the attachments. Correction, withdrawal, and restoration. Require plaintiff and government to withdraw, correct, or supplement any notice, report, complaint, blah, 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 to any third party that states that implies that the May 29th order made findings or entered restrictions it did not make. Require plaintiff and government to send a court-approved corrective notice to Patreon, YouTube, Steam, Valve, and any platform revealed by productions that stating that the May 29th order did not adjudicate Synapse Chronicles as unlawfully used SSR Wives IP, or did not adjudicate Synapse Chronicles as violating plaintiff's rights, did not enjoin promotion or hosting of Synapse Chronicles, and did not order any third party platforms to remove Synapse Chronicles. Require plaintiff and government to take reasonable steps within their control to request restoration, reinstatement, republication, strike removal, account removal, and status review for any platform restriction caused or supported by a false statement concerning the May 29th order. Require the plaintiff and government to file a sworn platform notice certification identifying every platform, payment processor, publisher, distributor, social media service, community service, storefront, investor, journalist, or other third party to whom they sent, caused, encouraged, or knew of a complaint notice concerning Synapse Chronicles, Corpse Works, David Cortez, Cori, blah, blah, blah. You know the rest. Emergency production and preservation. 13. Require plaintiff and government to produce within 24 to 48 hours or another emergency period set by the court all platform notices, complaints, reports, trust and safety. And we're getting the same thing. 14. Required plaintiff and government to preserve all platform records, deleted posts, drafts, account recovery records, access records, support tickets, takedown requests, climate submissions, appeal records, restoration records, YouTube copyright strike removal records, Discord strike removal records, accused video message IDs and URLs, accused messages, claimant identities, analytics, traffic records, wishlist records, subscriber revenue records, and public statements concerning the same topics. Require plaintiff and government to preserve all company cap table, payroll, banking ownership, founder splits, Star Wives, Hen Studios transfer, the October 13th opt-out, prohibit government and persons acting in active concert with them from accessing or attempting to access, using, disclosing, or relying on Simon Dickerson's personal iMessage, Signal, Gmail, Google Drive, or other personal account contents, except through lawful discovery in a court-approved privilege providence process. Require the plaintiff and government to identify, preserve, sequester all personal attorney-client privilege, work product, legal, family, unrelated, private, independent business, stealth, agent IO, or similar materials obtained by Simon's personal accounts, devices, and prohibit use or disclosure unless approved by the court. Require plaintiff and government to preserve and produce records sufficient to show how plaintiff learned of stealth agent IO, what personal account or device materials were accessed or used concerning it, and all stealth XYZ stealth GDP records later concerning the stealth agent product, including naming, concept, design, marketing, and public release, founder lockout, and status quo. Find for the purposes of temporary relief without final adjudication that Simon Dickerson made a substantial showing of founder-level ownership economic rights based on oral implied agreement, co-owner conduct, joint control, private economic sharing, government's party admissions, Simon's reliance in performance, and the October 13th, 2025 waiver demand. Find for the purpose of temporary relief without final adjudication that defendants have made substantial showing that government gave or agreed to give SSR Wives Hen Studios to Simon as part of the founder split, and that plaintiff/government may not use disputed ownership claims as if they were finally adjudicated to pertain platform takedowns, account restrictions, asset transfers, public ownership representation, or business interference. Prohibit plaintiff and government from selling, transferring, liquidating, encumbering, or materially disposing of stealth AI, XYZ AI, stealth GDP assets, in SSR Wives Hen Studios assets, founder split IP, domains, source repository is blah blah blah, without notice to the defense counsel and court approval. Require monthly business status reports to Simon through counsel or other court-related approved mechanism concerning material, business events, revenues, major spending, without prejudice to any party's final merits position. Restore or preserve Simon's pre-lockout compensation / status quo by requiring plaintiff government to restore Simon to former payroll at $30,000 a month during emergency proceedings, or alternatively required plaintiff to deposit $30,000 per month into court registry or counsel-controlled escrow pending adjudication. Alternatively, if the court is not prepared to order interim payment, payroll restoration, or escrow before testimony, grant the platform misuse, correction, preservation, reporting, no use, account access, or emergency discovery relief immediately, and permit Simon to renew interim compensation status quo relief after expedited testimony and production. G. Emergency discovery. Order the expedited deposition of Joseph Garman before the emergency evidentiary hearing, or permit defendants to call him as an adverse witness at the hearing if plaintiff prevents or delays the deposition. Or expedited dispositions of Alex Shapaloff and Gabriel Kaprinsky, or other procedurally proper testimony concerning the Simon Gurman founder status, equity, understanding, founder split, September 25th through October 14th, 2025, communications, the December 13th lockout, instructions not to communicate with the defendants, compensations or incentive, testimony preparation, platform complaints, public statements, personal account access, and alleged civil conspiracy. Create an emergency discovery carve-out from any pending protective order motion for ownership, founder of split, account access lockout, witness pressure, public harassment, public platform account interference, platform DMCA misuse, stealth agent IO, and account privilege issues. Grant other such relief does court deems just and proper. Conclusion. Plaintiff and Gurman should not be permitted to use materially false statements about this court's May 9th, 29th order to obtain private platform restrictions that the court never ordered. The court record shows immediate and irreparable harm to Synapse Chronicles, Corpseworks LLC, defendants, and related third parties. It also shows a broader need of preservation, disclosure, expedited discovery, personal account protection, and status quo relief arising from the founder lockout and disputed ownership record. Therefore, the defendants respectfully request to grant this verified emergency motion to clarify or modify the May 29th, 2026 preliminary injunction as set forth above, enter temporary injunctive relief, order emergency preservation or corrective platform relief, authorize expedited discovery, and grant all further relief the court deems just and proper. And we have signed, and that's the end of the document.
So, in short, through their actions, XYZ have opened themselves up to a strongly defensible countersuit.
Yes.
For major damages.
Yes, and what makes it even worse is that if we take a look at the broader implication of it,
Or which broader implications?
well, the broader implications is that the court will finally have to tackle this mess, one way or the other. And it's like, does the court believe Simon, or does the court believe Yosef at this point? And there's supposed to be a hearing going on right now, discussing it. Now, if there is something going on that requires Yosef to shall we say implement the order as he interprets the order, then we have major problems going on with this judge. But that's neither here nor there. Mr. Lynn, I'd like to thank you for watching for being here today. And I'd like to thank all of you watching the W2 Report live and in person. We're probably gonna take Tuesday off, but please enjoy Thursday's show as we go into as we present a story that we're building toward a very, very interesting discussion on. Lord Crocosquirrel will be joining us, I think, for a discussion on AI. And if you want to join us in our community, we do have links in the description. And follow us on all the social media platforms. And if you do join us, there will be cookies on the other side. So, between now and the next time we see you,